Second last.
Yes, sir. Yes, sir. We don't need that because I have a separate intro.
Right.
Okay. Should I start?
Yeah.
Good evening, all, and thank you for joining us today. My name is Akshay. I'm the. Sorry, one second.
Continue. I'll just.
Sir, you'll have to turn off your PowerPoint.
Yeah.
Turn off the screen sharing. Yeah.
Sir, can you turn off your screen share, please?
अरे देख तो screen share. Yeah. You want anything from my side?
No, I need you to turn it off so I can start.
Yes. Turn off for this. Yes, yeah.
Stop the screen. Okay.
Yeah.
Thank you. So good evening, all, and thank you for joining us today. My name is Akshay. I'm the project director for Moneylife Foundation, and I'm delighted to welcome you all for another important session. Before we start, for those of you who are new, this webinar is being organized by Moneylife Foundation. We are a 13-year-old non-profit organization primarily engaged in spreading financial literacy and advocacy for savers. We also make efforts to spread consumer awareness on various issues that are of interest to our members. In today's session, we are looking at a topic that has been of great interest to both cooperative housing societies and also to builders. Redevelopment has become quite popular since it is the most practical, economical, and long-term solution in a scenario where old structures are proving to be uneconomical or obsolete. However, there are many factors and questions that arise during the process, which have to be considered and addressed in a diligent and efficient manner at each step. So today we have invited Advocate Vinod Sampat to speak on the topic of redevelopment and to enlighten us on the intricacies and challenges that one might face when opting for the redevelopment process. Before we start, allow me to introduce our speaker. Advocate Sampat has been a practicing lawyer for over 30 years and has focused his efforts mainly on issues relating to cooperative housing societies. He has authored many articles on property-related matters and has written over 100 books on housing societies, transfer of flats, recovery of dues, registration and stamp duty, and other such matters. Before I hand it over to Advocate Sampat, allow me to share a few ground rules for today's session. We have kept all of you on mute for the benefit of all involved and will only unmute you during the Q&A session. For optimal viewing, we suggest that you keep the webinar on speaker view. This webinar is being recorded and shall be uploaded to our YouTube channel, Moneylife TV. During the Q&A session, please use the raise hands button available on Zoom if you wish to ask any questions. Also, a sincere request to please keep the questions short and to the point. Please feel free to the chat section to use the chat section to post your comments, questions, or observations. But do send it only to the public forum, marked to everyone. Please do not send us a private message as we will not be able to monitor or reply while the session is live. Please also note that your cameras may be on by default and you could be broadcasting your background and homes for everyone to see. If you wish to maintain your privacy, you may turn off your camera now. And without taking too much of your time, may I ask Advocate Sampat to please take over and start the presentation. Sir, over to you.
Good evening, friends. To begin with, I am thankful to Sujata Dalal and Moneylife Foundation for giving me an opportunity to express my views. The topic is conveyance and redevelopment of property. As you are aware, whenever there is any proposal for redevelopment, it is just as necessary that the property card, first and foremost, should be named in the name of the legal entity, which normally is a cooperative housing society. If you don't have the property card in your name, then in such scenario, obviously the person in whose name the property card is there, his consent is required. Now let us understand the intricacies with regards to getting the conveyance of the property. Say the cooperative society which wants to go for redevelopment has been registered in the year 1990. Now the building is old and we require the same to be redeveloped. When a proposal is being made, the municipal authorities recognize the person in whose name the property is standing. Many times it so happens that in spite of the fact that flat purchasers have paid the valuable consideration to the builder, for reasons best known, the builder does not transfer the property in the name of the legal entity. The reasons for the same are many. The builder wants to utilize the balance FSI, TDR benefits. They arise over a period of time. In simple terminology, prior to DP Plan 2034, FSI was 1, fungible FSI was 0.35. This is applicable in city. In the event the property is situated in Mumbai suburban area, the TDR was 1 and 0.35 was the fungible TDR. So in simple terminology, if your plot was of say 1000 square meters, 1000 plus 350 plus 1000 plus 350 equal to 2700 was the construction that was permitted. Now with the advent of 2034 DCR, the linkage of FSI TDR is linked to the width of the road. By and large, redevelopment of property is a win-win situation for all. But we should not forget one thing. When there is abundant stock, the supply increases, which in turn affects the standard of living of the people. Many of you may not be aware that in Mada colonies at Pantnagar and Vikhroli, the potential of construction is 10 and 12. That means for a 1000 square meter plot, construction that could be permitted is 10,000 square meter or 12,000 square meter, if one takes into consideration the tidbit and other benefits available. In fact, today the scenario in Mada is such that they are not able to utilize the full potential because of the restrictions in the nature of the size of the plot. At certain places, it is in the landing zone of the aeroplane. Practically in Ghatkopar, we face this problem. When you look at the concept of conveyance, as I mentioned earlier, the property needs to be first transferred in the name of the legal entity. When the building is going for redevelopment, the builder, the potential builder will say, you don't worry, I'll get the conveyance that from the earlier vendor. He will give his no objection. Obviously, that comes with the price. Here, the earlier builder who had already done his construction and is supposed to get the thing done for free gets a premium. Let us analyze the stages of conveyance. You can get it through the court of laws by approaching High Court. You can get it by approaching deemed conveyance authorities. You can get it by approaching consumer courts. You can also prosecute the builder for violation of the laws of the land. Deemed conveyance is a piecemeal situation where you go from one platform A to platform B to platform C. First, let me take the deemed conveyance aspect. You fill up a few forms at the office of the district deputy registrar. Needless to add that in my opinion, that involves speed money. After that, you have to go to the registration office. Their documents have to be signed. After that, you have to approach the city survey office. City survey office also may take out some technicalities. For example, the property as per city survey record is 10,205 square meter, and actual certificate may be for 10,204 square meter. But this 1 square meter difference will make you go back from pillar to post to the older rear office, get those records rectified. Then again go for registration and then get all this procedure redone. We have seen a lot of complaints in deed conveyance. Many times it so happens that you get the first ladder, you climb the first ladder, then the concept comes of payment of stamp duty, which results in a limbo as people are not willing to pay the proper stamp duty. So you have a paper tiger, a piece of certificate, which is nothing more than a paper tiger. But if you are approaching consumer courts, and we have seen that even the increase of stamp duty has got to be paid by the builder. When you go to consumer courts, the prayer will not be just for getting the conveyance of the property. It will be for getting the property card transferred in your name. That involves the formalities and modalities connected with getting the records transferred at the city survey office. Original as a legal entity, cooperative society, you must have the original documents of the title to the property card. The property tax bill should be transferred in your name. The water bill should be transferred in your name. Section 11 of the Maharashtra Ownership Flats Act clearly stipulates that promoter to convey title, etc., and remove all the defects related to construction or related to the statutory obligations. Normally, the builder will show, see, look at this agreement. You have agreed for this, you have agreed for that. Well, agreement is nothing but a contract. It is a contractual obligation. What is written in the statute is the statutory obligation. And whenever there is a conflict between a contractual obligation and a statutory obligation, obviously the provisions of the statute will prevail. So even if you have written something in the agreement, you don't have to worry. There are various statutory clauses in the statutory clauses wherein you are protected. Under the Maharashtra Ownership Flats Act, we have the model agreement. Model agreement stipulates very well-defined clauses. You cannot have an agreement as per the sweet will of the builder. Government has specifically stated that these clauses are statutory in nature and you cannot supersede those clauses. Presuming for a fraction of a second, you have not written those clauses in your agreement, by the builder does not write that agreement, then also those clauses will supersede the provisions of the contract. The builder may write XYZ clauses, and if that clause is conflicting with the statutory clauses, then obviously the statutory clauses will supersede and that will be implemented. One of the classic things which we have seen is builder does not include the owners of the property as a party to the document. What is the reason for him not doing so? As you know, builder and the landowner, they enter into some transaction. And if the landowner is implicated as a party to the agreement, he may not come for registration. The bankers will not give a loan. From my experience, I have seen even the big sharks, they overlook many things wrong by the builder. And one classic example is the banks. For a small purchase of a flat of 2 BHK, 3 BHK, they will ask you so many documents of title. But when it comes to builder, very conveniently, the practice is ignored of the statutory obligation. The law stipulates that the owner of the property should be joined as a confirming party. This is very clearly mentioned in black and white in the Maharashtra Ownership Flats Act. I have no hesitation in saying that in spite of this clause openly being revoked by, openly being flouted by the builders, banks are more than willing to give loans to the builder or the flat purchasers. They know it very well that this is a mistake being committed by the builders. But as the saying goes, the king is right. In spite of they knowing that this is the wrong thing being done by the builder, yet they overlook it. The second thing which is overlooked is the model agreement categorically stipulates under clause 4, I think, that the builder, when he is constructing the property, he has to mention specifically in black and white what is the FSI potential of the plot. If the builder mentions that FSI potential, obviously he cannot construct more than that. So definitely and intentionally, this clause is violated by the builders, and they don't write many clauses which are compulsory in nature. If you look at the model agreement, when you are purchasing a flat as a flat purchaser, you are paying certain amount not just for the four corners of the flat, but you are paying certain amount for the common areas and amenities appurtenant to the premises. The implications of the same is open parking, stilt parking, all such open spaces, terrace flat, the terrace area, all these things belongs to the society. But what does the builder do? He takes something extra for a person who is taking parking space, and that goes sweetly in his pocket, which he is not legally entitled to take. Now, with the advent of RERA, this certain amount of this common area, this type of things are legally being permitted to be sold, which in my view is not correct, but we all know how builders are. A plumber requires a license, an electrician requires a license, but all that a builder requires is a sweet tongue and a smiling face. He does not require any license. With MOFA, education is there for estate agents. I am of the opinion that more education is required by the builders community, because they do so many wrong things within just to profit them. There are observations of the Supreme Court in the case of Rents Colony, wherein the judge, when the Supreme Court has gone on record to say that it is common knowledge that builders flout the laws of the land, and when such things are being done, one can safely presume that they have done it. They may have done it intentionally, because builders are supposed to know the laws of the land in a better manner. These are the observations of Supreme Court in French Colony judgment. We have seen so many projects which are getting stalled. We have seen so many projects where builders have failed to comply with their promises. What is the best way to protect your interest? The best way to protect your interest is appoint a good lawyer when your society is going for redevelopment. Irrespective of the fact who is your lawyer, you need to take a few precautions. One precaution is there should be an exit clause in your development agreement. Supposing you have entered into a redevelopment agreement with the builder, it has been stated that the project will be completed by 3 years, within 3 years. He may demand grace period, say 6 months. So you should be very firm and ask a question: what happens after 3.5 years? Very politely and innocently, the builder will say, I was paying you rent of, say, 50,000. Now I'll pay you rent of 55,000. The next question from your side should follow is, okay, I give you 6 months more time after 3.5 years. still you have not completed your project, then what? He will try to give evasive replies, and you have to be very firm and have to insist that there has to be a termination clause in the agreement itself, so that at one point of time you are free like a bird. Experience shows that many times, knowingly or unknowingly, the managing committee members fall for the trap of the builder, and at times they are also corrupt. There have been so many instances where the builders are in collusion with the managing committee members and the project suffers. Second precaution that requires to be taken is when you are going for redevelopment, be blunt and ask him what is the maximum construction that will be done by the builder. The maximum construction should be put up in black and white, because he will always portray a picture that he is not getting much profit and hardly there is any scope. The length and the breadth of the plot are fixed. On the basis of the length and breadth of the plot, the construction is done. But there are so many incentives available. As I mentioned to you, the FSI can be 10 and 12 for MADA plots. It is slightly the subject of an architect, the built-up area, everything. I will tell you something very unusual, which you will also be surprised. If you do a phone call of ₹1, there is a very good authority like TRI, which supervises and monitors. RERA is still a baby which has got a lot of handicaps which have got to be removed. And the best example of it is its orders are nothing more than a paper tiger, because it is not acting in a harsh way against the builder. It's in the last few years, which all of us know. Builders don't take RERA that much seriously because it has not started showing its teeth. The need of the day is to levy hefty penalties on the builders. Put them behind bars. Then only the lessons will come in the appropriate manner. Today, builders plead before RERA that if anything happens to my this thing, the whole project will suffer. And in spite of one or two flat purchases being done a wrong thing happening to them, others will suffer. And RERA is also lenient on builders, which we all know. Now, coming to the aspect, as I mentioned to you, harsh questions should be there on the builder. The best thing is insist always for lead on the plot. Supposing on the plot of land which belongs to the society, 10% of the constructed area should be allowed to be sold by the builder only after he has completed the project and has obtained the building completion certificate. Earlier, no one was obtaining building completion certificate, and they used to obtain occupation certificate. What was the reason of not obtaining the building completion certificate? The reason for obtaining the building completion or not obtaining the building completion certificate was the deposits that were lying with the municipal authorities were, say, of 5 lakhs rupees. And the cost of obtaining building completion certificate after getting occupation certificate was more than 75 lakhs or something. We all know, if I have to put it in a very humorous manner, BMC, as far as builders' viewpoint is concerned, or the common man's viewpoint coming, of course, it is to some extent with the element of humor in it. BMC stands for Bachelors and Masters of Corruption. You will find expensive cars at the offices of building proposal departments, where I am told 8-digit amount could also be involved just to get the building completion certificate. Whether it is right or wrong, I don't know. But this is the general impression. If you go for construction of a building, there are so many things that have got to be complied with. Let me put it to you that even for ladies working there, crutches have got to be provided. On a plot of land where building has to be constructed, it is difficult for the builder to create so much space. So many times they ensure that their violations are over. Your agreement, as I mentioned, should be a watertight agreement, leaving no scope for play. You have to be very harsh. Where are the normal plays being done? The normal plays being done by the builder is a series of promises are given verbally. Okay, don't worry, I will take care of it. So I will look into it. If your relative wants a flat, I will give some discount. And we have seen flat purchasers, the office bearers, knowingly or unknowingly, they fall for a trap with the builder. Humorously speaking, builder, यानी बिल का कभी डर ही नहीं होता है. Buy back, buy from me, see my back. Leakage, it's guaranteed. Leakage तो guarantee है, आने वाला ही है. 24 hours water. You will get water either from the wall or from the tap, but water you will definitely get. And last one is builder की सही पहचान, माप में ही पाप है. Carpet area, built-up area, super built-up area, sellable area, all these are terms utilized to make small area look bigger. I will not say that builders of India are not following the laws of the land. Some of you might have read in Times of India first page that the builders in USA have even started selling land on moon as if they have themselves visited the planet, the moon, and they have seen that thing. But this is the ground reality which is happening. So as a flat purchaser, as a member, you have to be extra cautious and you have to see to it that whatever you are going for, whatever commitments are being made by the builder, he is honoring those commitments. For all those things, what you require is an agreement which is foolproof. You should not allow morality to come in picture when you are documenting, when you are executing an agreement. It has to be a watertight agreement. One tip I would like to give to all my listeners is, whenever you are going to a builder's office or you are calling a builder, get everything recorded in black and white. Don't trust or don't let them talk to him as if in good faith. You have to ensure that everything is done in black and white, properly documented. One common thing which we have observed where the society fall in a trap is, it is said that if there is any dispute, then the matter will be referred to for arbitration. And let me tell you, arbitration is not easy. As a lawyer, I know the implications of it. So I always tell my friends, well-wishers and clients that always have a clause in the agreement that in the event of there being arbitration, it should be done by a retired judge. And the cost of arbitration has to be borne exclusively by the builder, and some fund should be taken in advance from the builder. We have the circular with regards to redevelopment issued by the cooperative department. But let me tell you, cooperative department, in my opinion, is cooperative. They don't monitor a thing once they give permission to the builder. They think that by giving the permission, their work is over. It is very, very difficult to get good output from builders because, number one, flat purchasers are not an organized community. They don't have legal knowledge. They easily fall for trap. In construction line, there are 1001 items. So if you ask for 10 items, the builder will go on speaking yes, because he knows that in other items he can easily cover up. If someone says, I'll give you A grade material, you will be happy. But in building line, C grade is better because it stands for quality. If A grade means it is not up to the mark. It is very difficult to see, it is very difficult to analyze which material is good or not. That requires a lot of experience, and unfortunately, managing committee members are not that much experienced. I explained to you the implications pertaining to conveyance, why it is important. We can get conveyance in a short span of time if you put the proper pressure approaching consumer court and the metropolitan magistrates court. Definitely there can be a good amount of pressure. If you are fighting a case as an individual, High Court says that if the person who is fighting a case is more than 60 years of age, then an application can be made to the court anywhere in Maharashtra to expedite the court hearings. These things are not known to many, and in spite of the fact you being senior citizens, you don't take advantage of things which you are legally entitled to take. When you put up such things, the chances of you getting justice are slightly better, in my personal view. When you go for consumer court case, it may take 3 to 5 years. But when you are going along with a criminal case, there is every probability that he will come for a compromise. You should know how to attack the builder. You can dig up, you can use the power of RTI. Find out the track record of the builder, how the other buildings have been constructed. Statistics shows that not even 50% of the buildings in Bombay have the building completion certificate. I am 50%, I am exaggerating. Not even, I would say 30-40% of the buildings have this conveyance as the building completion certificate. You look at the scenario, 1963 Ownership Flats Act came, 1947 we have got the independence, and now we are in 2023. So you can count the number of years, but still, as far as conveyance of the property is concerned, it won't be more than 20-25% of the properties have got the conveyance of the property. For a 1 rupee telephone call, we have a good lobby and a good system of check, which ensures that phone call of 1 rupee is properly monitored. But here, crores of rupees are parked in real estate, but we don't have a very powerful lobby of flat purchasers. No wonder, we all know, politicians also park their funds in the nature of being a builder or in having partnership with builder or some collaboration with builder. Real estate, for some reason, since independence, is linked to a place where you can park your funds in a very safe manner. Earlier, the returns were also good. And if you go to a builder or speak something, builder will say, okay, I'll give you back your money. By the time you purchase the flat, and by the time you go to him with after 1 or 2 years, 3 years, the prices would have skyrocketed. Not to mention the fact that there was a possibility of cash being exchanged earlier at the time of booking. So always from day one, you are at the mercy of builders. As a flat purchaser, when you are purchasing a flat and staying in a cooperative society, you have to ensure that the said property, you get the title to the property. You have to remember 2 things. Either the property is freehold or it is leasehold. If it is freehold, you get the conveyance of the property. If the property is leasehold, you are entitled for lease a deed of assignment. Say the lease is of 99 years. Building is constructed by the builder and 15 years have passed. Then you will be entitled for the assignment of the lease, 99 minus 15, whatever it comes to. That is what one of the differences which we see is not properly utilized. Some builders, to put pressure when they are selling the property as a lease, they give a lease to the sister concern, and when you go for redevelopment, they say that sister concern also has got a right in this property, so you have to pay some such amount to the sister concern. As far as redevelopment is concerned, before we start with the redevelopment, I would like to share with you, there is a new concept that has come up, is of self-development. Friends, it is not easy to go for self-development. How many of you are aware that when you go for self-development, 3% stamp duty has got to be paid as per Article 25A of the Maharashtra Stamp Act? This is invariably not told by the project management consultant, PMC, whom many humorously called as Pura Malai Kamalo. This 3% is on the society. Builder or the PMC is a visiting faculty in the life of the building, and obviously in a 4-5 years from now, he will go away. Once the builder goes away, the right being annexed, attached to earth, the stamp authorities are bound to recover the same with 2% penalty for the period for which the duty has been evaded. So this is one point which we have to keep in mind. Secondly, for redevelopment, you need technical experts. It is not easy. The concept of redevelopment looks very attractive. Banks were also earlier giving loan. Again, they stopped it. The Reserve Bank point of view, also some restrictions came. Many builders defaulted and they call themselves PMC and so on. Those things are there. But I will not advise you to go for redevelopment. In my view, in the whole of Bombay, not even 25 projects of redevelopment have been completed till today. If I am wrong, I would like to be corrected. Similarly, I will say the agreements that are being drafted under MOFA era and now the RERA era, I will say they are not as per the statute, the way it is being drafted. The words are being intentionally distorted to favor the builder. Now, when you come for redevelopment aspect, proper research is very much important, and the best tool for you to get information is internet. Talk to your friends. The criteria of selection of a builder is also equally important. I can go on, but I have prepared the slides and I will request Moneylife Foundation to start with the slides. Okay, come to the next slide, please. I'll go fast on the slides. The basic criteria with regards to going for redevelopment is the title of the property should be with you. That comes with property card. That is very, very important. I explained to you that if the builder, if your society has not got the property card transferred in your name, again the earlier builder, you have to approach consumer court as well as file a criminal case. The laws of the land are such that when a builder is executing an agreement with the flat purchaser, he has to implicate the owner of the property as a confirming party, so that the title of the property is transferred in the name of the from the name of the legal entity to the actual flat purchaser's legal entity, namely cooperative society. Pausing here for a moment, earlier, whenever the agreements were being done, the builder used to call himself a developer and he was paying 1% development agreement charge. There was stamp duty on development agreement at 1%, which was not the correct scenario in view of the fact that the developer was taking the money from the flat purchaser. So he was acting for all practical purpose as owner. Earlier, the stamp duty was 10% and on development per agreement, it was 1%. But now, for the last few years, the government has made it uniform for the owner conveyance also, as well as for development agreement, it is 5%. And of course, the metro says 1%. But by and large now, what has happened is people when they prefer taking conveyance rather than development agreement because it is not lucrative for the developer. Next slide. When you as a legal entity wants going for redevelopment, when you as a legal entity purchasing a flat from a cooperative society, you have to have the occupation certificate, building completion certificate, statement of account, conveyance, original documents of title to the property, and you have to see that in the property card should be in your name. You have also to see that the proper stamp duty has been paid by the builder. If you look at the fine print of the agreements being executed, you will get many masalas. Many times it so happens that the builders for the earlier transactions, they do not pay the proper stamp duty in spite of the fact that they are duty bound to pay the same. Next. I also mentioned to you that each and every flat purchaser under the MOFA era have paid money for parking. Builder had no right to sell open parking or state parking. Now the scenario in RERA is different. And RERA has tried to favor the builders, thereby rights have been given to the builders to sell parking space. Now, when you look at model agreement, clause number 4 stipulates that what is the FSI potential of the property, that has got to be mentioned in the statutory obligation. It's a statutory obligation, and it is compulsory to be mentioned. But very rarely builders mention the same in the agreement. Next, if you look at the model agreements under MOFA, it very clearly mentions that 1, 2, 3, 4, 5, 8, 9, 10, 11, 12, 13, and 22. This is the note to the model agreement, which is a part and parcel of Maharashtra Ownership Flats Act. When you will read it, you will see that these clauses are statutory and mandatory, and even if there is any departure, the same will not be binding or enforceable upon the parties because they are void, they have been issued. And note number 2 says that the owner of the property has got to be joined as a confirming party so that the terms and conditions are binding on the owner. Friends, if you are a flat purchaser and the builder has failed to comply with any of these conditions, believe me, friend, that these two are your Brahmastra. Many times the builder, when you take up these 2 points, he will come for a compromise and you may not have to see the judgment being delivered by the actual court. There is every possibility that after issuance of a legal notice itself, he will come to you for a compromise and resolve your issues. The answer for that is when you are executing an agreement with the builder, stamp duty is paid, document is registered. Tomorrow, if the owner has not been joined as a confirming party, you can tell the builder this is your mistake and now you pay the stamp duty. You purchased the flat 10 years ago and today the stamp duty is high. You will have to pay the said amount. Next slide. I am talking specifically about MADA societies because it has got different set of rules in the play game. Let's take a look at those. What has been promised and what is constructed is entirely different. At many places, builders don't give the agreement, they just give an allotment letter. That examples are Sakar Nagar, Tilak Nagar, Viproli, Pant Nagar. All these are there are problems near to the Ghatkopar central suburbs. These types of problems are seen. The reason behind not executing individual agreement is to save on stamp duty. Now, luckily, the government has said that if the development agreement stamp duty has been paid and all the flat purchases are included as a party, there won't be any stamp duty. You will get a set off. But that was not so in the earlier years. Next. There are judgments that occupation certificate is a must. And there is one judgment which says that maintenance charges should not be collected till the receipt of occupation certificate. Personally, I don't agree with this judgment. In my view, in spite of the same judgment being in existence, that will not be the correct stand, is my personal view. I also already mentioned allotment letters given, individual agreements not given, but that is a statutory obligation of the builder. RG stands for recreational ground. We have seen some buildings coming up in recreational ground in Shambur area, where that recreational ground is meant to be kept vacant so that children and old come and they can utilize that spare time sitting there, relaxing there. But builders for the profit, they many times construct buildings there also, which is not correct, and it definitely affects the lifestyle of the people who are residing in the said area. Whether it is MADA or elsewhere, once you have handed over the plot of land to the builder, very rarely you will see cooperation from the builder. They, in the first instance, they don't respond to you, and they don't even literally. I would say they don't care for the flat purchases once possession is received, and they will not deal with you. They will just tell one of the secretaries or one of the sales girl to talk to you. Yes, sir. Yes, sir. Yes, sir. But they don't give much importance to flat purchases once possession is obtained in redevelopment matters, is what is the experience of quite a few people. Next. Now let us take a look at the problems which are being faced at the time of redevelopment. All promises are made. Builders do not have funds. They talk very big, but when it comes to investing, it is not, the desired funds are not there. The market scenario cannot be predicted, which results in a situation where the whole game of the whole plan schedule gets upset. Many times we have seen managing committee members are themselves having vested interest. At times it so happens that everyone is promised X area in MADA, but that one does not fit. So one flat is on, one room is given to X, one room is given to Y. Federations are not formed, stamp duty implications are not understood, tax implications, GST implications are not properly understood. Some people say we want money